Welcome to the Macs Future Weekly Podcast. All Apple talk and no chit chat.
Okay, welcome to the Apple Podcast. This is number 126, and today is August 26, 2012. This is Lex at Macs Future, and boy, there's a lot to talk about, isn't there? I think we're going to spend a lot of this podcast talking about the massive victory that Apple scored in that jury trial against Samsung and against really the Android world that Google created. So this is coming out on Sunday, August 26. I've had a little bit of time to digest the victory that came down on August 24th, Friday. So let's get to it, and you can help out this podcast by giving it a positive review in the iTunes Store or on YouTube or on Bloop TV, or go to the MacsFuture.com website and check that out. So listen up. Okay, well, unless you've been living under a rock, you probably have heard that Apple scored a really massive victory over Samsung in a big jury trial in Northern California. I guess it's in San Jose, in federal district court. This has been a 3-week jury trial, and it was at the Robert Peckham United States Courthouse and Federal Building before Judge Koh, K-O-H. And Apple scored a massive victory. It came down in the early evening Eastern Time, United States, on Friday the 24th, but it was in the afternoon California time on the 24th, and the jury came back, and it was very exciting. Let me get to the punchline. So Apple totally won. It's considered a huge victory. The jury basically found that dozens and dozens of phones that Samsung has issued violated like 6 different patents that Apple sued on, and the jury awarded Apple $1.049 billion in damages. And Samsung had sued on some counterclaims that were essentially like FRAND patents. These are standard essential patents. And Samsung lost all the counterclaims. So it was a total knockout victory. And so what were these patents, and what were the claims that were litigated, and what were the big victories? Well, let's go through the patents. The first patent was patent number 381. It's known as the bounce back patent, and basically this is sort of like a software patent. And basically, as you get to the top or bottom of an iOS page, if you pull it down, it will then bounce back into place. And the jury found that all 21 Samsung devices named by Apple violated the 381 patent, and when asked if Apple proved that Samsung took action that it knew would result in infringement related to the 381 patent, the jury said yes to all 21 devices. So that is pretty damaging, because that's a really nice interface feature for the iOS devices, the bounce back. Another software patent that Apple won on was, let's see, what was it called? It's the, hold on, let's see. It's the, well, that was the 381, and it's the 915 patent, number 915. It's known as the single scroll or pinch to zoom, and it covers the use of a single finger to scroll through a page, as well as using 2 fingers to zoom in and out, because basically the touch interface of the iPhone recognized that. And the jury found that all devices except Samsung's Galaxy Ace, the Intercept, and the Replenish infringed on this 915 patent. And again, when asked if Apple proved that Samsung took action that it knew would result in infringement related to the 915 patent, the jury said yes for all devices except replenish. Now, why is that significant? If Samsung knew it would result in infringement, because that's known as willful violation. And if there's willful violation, then the judge after the trial can increase the penalty, or impose a sanction which is triple the dollar amount that the jury awarded. So that's pretty significant. The third patent, which is also a software patent that Apple proved that Samsung violated, is the patent number 163, which is known as the tap to zoom patent. And the tap to zoom patent allows for the user to tap the screen on an iOS device twice in order to zoom in and out. In other words, if you quickly tap on the screen twice, it will zoom in and out. So if you, for example, navigate to a website on your iPhone and tap twice, you can see the view at the right. If you tap twice again to zoom out. And the jury found that all but 8 devices infringed in this patent. And so the ones, I guess, that infringed included the Captivate, the Samsung Captivate, Continuum, Gem, Indulge, Intercept, Nexus S 4G, Transform, and the Vibrant. And when asked if Apple proved that Samsung took action that it knew would result in infringement regarding this pattern, the jury said yes, except for the 8 devices that it didn't find that violated it. Now, the next ones had to do with the sort of physical design of the iPhone. And let's see. Hold on. It's called the D677 patent. The iPhone front, in other words, the distinct front of the iPhone. Basically, Apple accused Samsung of infringing on this patent, which is like a hardware patent, on 13 devices, and the jury found that Samsung did not infringe on the D677 patent with the Galaxy Ace, but that it did infringe with the Fascinate, the Galaxy S, the Galaxy S4G, the AT&T Galaxy S2, the International Galaxy S2, and the T-Mobile Galaxy S2. And the Galaxy S2, the Epic, so a whole bunch of phones except the Galaxy Ace. Now, if you're looking at the video version of this podcast, if you I went to Samsung's website, and if you look at the Galaxy Ace, it does sort of look a little bit like the general shape of the iPhone, but it is a little distinct in some ways. If you look at the bottom, the buttons are different. The home button and the return, there's some additional buttons. So the front of the Ace does look a little different than the iPhone. So maybe that's what the jury was dealing with. Now, the next patent, and if you look in the video version of this, I have actually a screenshot of the actual jury form. And the next patent was the D087 patent, which is the back of the iPhone. And basically, the jury found, you could see in this little check mark, that Apple alleged that 1, 2, 3, 4, 5, 6, 7, 8 phones violated the back of the iPhone, and Samsung was found to have violated the back of the iPhone with the Galaxy S, the Galaxy S 4G, and the Vibrant, but several others, Galaxy S's, were not considered to be a violative, but at least 3 of the phones, the back of those smartphones were considered violative. But here's an interesting one. So the last one is the D305 patent, and that is the home screen with the icons of the iPhone. And Apple alleged a whole bunch of Samsung phones to have been have violated that patent, and on all of them, Samsung was found to have infringed, including the Captivate, the Continuum, the Droid Charge, the Epic 4G, the Fascinate, the Galaxy S, the i900, that is, the Galaxy S 4G, the Galaxy S Showcase, the Gem, the Indulge, the Infuse, the Mesmerize, and the Vibrant. Now, bizarrely, the next patent, one place that Apple lost was the D889 patent, which is the overall trade dress of the iPad. And Apple alleged that the Galaxy Tab 10.1 Wi-Fi version and the 4G version violated that. And bizarrely, the jury found that it did not violate that Apple patent, even though previously the judge had issued a preliminary injunction blocking that device after the judge made an initial ruling that that device did infringe the patent. So, it's a big victory. So, the next part of, I guess, the jury forum, and they read this out loud in court, and I'll talk about that. That the jury dealt with was, did they find that Samsung took action that it knew or should have known would induce its subsidiaries in the United States to infringe these patents? And generally, for most of the patents, the jury found that the parent company did cause the subsidiary Samsungs to infringe. This is like a technical thing, because I guess for some of the phones are actually distributed by the subsidiary Samsung in the United States. And so, can the subsidiaries be on the hook for the conduct of the parent? Then there was the question of, have you found that Apple has proven by clear and convincing evidence that Samsung's infringement on these 6 different patents was willful? And on all except the back of the iPhone patent and the iPad, because the iPad one they didn't find to be a violation, but for all of them except the back of the iPhone patent, they found that Samsung willfully violated Apple's patents. And that's really bad for Samsung, because it's willful, the court can consider on a motion to impose triple penalties. It goes on to ask, has Samsung proven by clear and convincing evidence that Apple's asserted utility and or design patents are invalid? And the answer was no, that it's for Apple. No, Samsung wasn't able to do that defense, and nor has, one of the defenses, I guess, that Samsung had was protectability. And the question was, has Samsung proven a preponderance of the evidence that Apple's registered iPhone trade dress is not protectable? And the answer was no for Apple. And so, these are just huge victories. And then sort of at the end of this stuff, there is a tally as to, the damages. So it goes, I'm not going to go through all the elements. I'm just going through this on the jury verdict form, but there's a tally, damages. How much was Apple damaged? And they initially got the number slightly wrong, because on 2 of the things they awarded some small amounts of money when, so they had to go back and fix it. But you could see the handwriting scribble, $1 billion, $49,343,540, and it's initialed by the foreman. And there's a spreadsheet, number 23, on the jury form, where they just break down the amounts of damages. These are damages to Apple. In other words, how Apple has been harmed by this infringement. And if you look on the sheet, I guess, let's see, some of the biggest damages are for the, I think it's for the Fascinate. The Fascinate, they awarded $143,539,179. So that seemed to be the biggest infringing. It probably has to do with the number of sales they had of the Fascinate. And the Epic 4G and the what else? The Vibrant, 89 million. The Galaxy S2 Epic 4G Touch, $100 million. So this adds up to like $1 billion. And here's the kicker. The kicker is that that Samsung lost all of its counterclaims on patents, and these were sort of sort of standard essential patents where Samsung was claiming that Apple's iPhone 3G and iPhone 3GS and iPhone 4 and iPod Touch and iPad 2 were violating these patents, and they basically ruled against Samsung and all of them and awarded Samsung $0. But the main basis was that Apple has proven by preponderance of the evidence that Samsung is barred by patent exhaustion from enforcing those patents, or at least 2 of the patents. So this is, a pretty big loss for Samsung. Okay, so what are these patents that Samsung was asserting in a counterclaim? Well, the 516 and 941 patents cover wireless technology. The 711 patent covers the ability to play music while using other apps. The 893 covered the ability to scroll through the photo gallery, switch to the camera to take a picture, and then return to the same point in the photo gallery. And the 460 patent let users take a photo, preview it immediately, and email it off. And like some of these, like the 516 and 941 are FRAND patents. They're standard essential, which is, think about this. Think about like you're a company like Samsung and the cell phone industry starting, and you're creating one of the first cell phones, and you want other cell phones made by other manufacturers to work with your cell phone wirelessly. So what you do is you create a technology, and then you tell the whole industry, hey, we're going to make this standard essential, and we pledge to license this cheaply to everybody. And anybody who comes along, because you need everybody to use the same technology for your product to work. So, cell phones, certain parts of cell phones, the technology, if you want it to work, like let's say, for example, Apple created FireWire and it wanted a lot of devices to work with FireWire and wanted to make it a standard. Well, it might license, might say it's a standard essential and then license it. And what Samsung's been doing is holding up Apple, because Apple was going after Samsung for non-FRAND patent violations. And so Samsung, desperate, that's my interpretation, to defend itself, pulled out some old, dusted off some old patents that are standard essential and said, yeah, Apple, if you want to sue us, then we're going to charge you a lot of money for these FRAND patents. And Apple's like, what are you talking about? These are standard essential patents where you agree to, license these for pennies to people, and now you want $5, $10 for us when you're charging everybody else pennies. So the jury saw through that and basically denied all of Samsung's counterclaims. So it was a real rout. I mean, Apple was seeking $2.5 billion worth of damages, and so the jury didn't find that Apple won on every claim and every phone, but it did find that six patents were valid, and that many phones violated those 6 patents, and that the damages are over $1 billion. So this is clearly one of the largest, if not, I think there was previously a large one that IBM was involved in, patent awards, damages by a jury, and it's epic. It's epic in size, and sends a very powerful message. Okay, now I want to take a little bit of a victory lap here because, I predicted that the jury would come out with a decision on Friday, and I did this on August 23rd, the Thursday, and I did it on Twitter. And, I did it at a time that the jury was out, I guess. It started deliberating on Wednesday, and a lot of people were saying, the jury's going to be out for a very long time, that this is way too complicated for a jury. And a lot of people sort of doubted that a jury could plow through all this stuff and get it right in a matter of days. And in particular, Nilay Patel, who is a journalist over at TheVerge.com, and I do read his stuff, and I generally do admire his writing. He was on Twitter, and I responded to something that he wrote about how complicated these jury instructions are, and how it's going to take weeks or something like that. He said for the jury to come back, or it's going to take a long time. There's not going to be a quick decision. And I emailed him, and if you're looking at the screenshot of this, video podcast, his handle is Reckless, and I wrote, "Jury will come back with a verdict tomorrow, Friday, I predict." And he responded to me. And let's see, here he is writing back 3 days ago. Today's Sunday. That was on Thursday. And he writes back, "Max Future, I think they're taking their job much more seriously than that." Sort of implying that if I'm correct, that the jury's not taking its job seriously if it's coming back Friday. Well, I do think the jury took its job seriously, and I think it was a good prediction that they would come back Friday. And I don't think he was right. I wrote back, and I made this point to Nilay on Thursday: the quicker they decide, the better it is for Apple. It's a standard axiom for plaintiffs. And I know a bit about litigation and trials, and generally in civil trials, if the plaintiff's case is strong, the jury is not going to take forever to decide, and not a lot of people saw this, and I basically said, look, Apple's case is very strong, and if it's going to go Apple's way, I can't see a jury, going beyond 3 days to decide this, and look, they've been sitting for 3 weeks, listening to evidence. It's not like they're just a potted plant. They're human beings. Anybody who's done a trial knows this, and they're absorbing arguments. They're absorbing evidence. And most jurors, and I sat on a jury once myself, totally different type of case, but, jurors aren't supposed to talk to each other, and we have no reason to believe that this jury did, but, the jury I was on, people would sort of give a glance to each other or whisper something as they're being led in and out, and the jurors are humans, and they start forming opinions as they see the evidence. They're doing their job. They're considering the witnesses. They're considering the evidence. And so I felt that if Apple's lawyers, Morrison Forster and Wilmer Hale, put on a good case, which it looked like they had, that there was a good chance that the jury would discuss it on Wednesday, that they would discuss it on Thursday, and then with the weekend coming up, they would try to wrap it up because, it's the summer. If they've had thorough discussion and are in agreement that there's been substantial violations here, the jury is gonna get through it and do its job. And I think I'm one of the few people on the internet who predicted that the jury would come back on Friday with a decision. I think people were in shock. I wasn't in shock. This is what I thought would happen. So when it happened, I was pretty thrilled. Now, over at TheVerge.com, this is what Nilay Patel wrote before the verdict came out, like before he knew there was going to be a verdict on Friday. He wrote, "Wrap up, 9 people alone in a room with a box of cell phones and tablets. Between them, they have to arrive at some 700 unanimous decisions that could ultimately distribute up to $2 billion. Some of these decisions seem relatively easy, while others will demand an extreme amount of concentration and focus just to understand before answering. This will not go quickly. And then in bold on their website, they write, this will not go quickly. And then it goes on and says, but perhaps that's the plan. And, he says maybe that they want to take a lot of time. But the bottom line is it didn't go crazy long. It went for like 22 hours. That's how long the jury deliberated. And 22 hours is a long time. People say 22 hours is not a long time, but it is. Think about how long 22 hours is. Sitting for 3 days, with 9 people debating and going through questions. It's a long time. Think how much you can get done in 1 hour of discussing an issue with a group of people. You can come to an agreement, particularly after you sat for 3 days, 3 weeks through evidence, or 2.5 weeks, or whatever it was. It's a long time. I mean, I have to sit in a conference sometimes for like a day. It's exhausting. So imagine these jurors, they're sitting there and getting piles and piles of evidence. They're getting witnesses from Apple, witnesses from Samsung, loads of exhibits, and they're absorbing stuff. And, if they think the evidence is clear for one party, they can make a quick decision. So, that's why I thought coming out that the decision would come out Friday night. I felt that, I had been looking at some of the evidence that Apple put in and what was Samsung's defenses, and I thought Apple clearly had the upper hand in that lawsuit. And so I thought it was completely reasonable to expect that having deliberated on Wednesday and Thursday and Friday, that the jury would try to wrap things up Friday night or Friday afternoon before the weekend came. Because, the weekend you lose some momentum. You're away from it. And if you're going to put in all this energy, why not try to wrap it up by Friday? And a lot of jurors, if they've had time to deliberate, they will try to decide before Friday. They want to go back to work on Monday. They want to go on with their lives. They want to enjoy the rest of the summer. And they're not going to drag things out, endlessly. They're going to try to do their job, and they're going to do it efficiently. And that's what happened, obviously. Now, some stories have come out regarding, what exactly has happened in the jury room, because a number of the papers somehow got a hold of some of the jurors, and the jurors are free to talk after the jury verdict came down. There were some reports that they went out the back door. Now, a lot of times jurors do talk to the lawyers for the plaintiff or the defendant to get a sense of what was wrong with their case or what went right with their case. Usually the team losing wants to know what went wrong, but I'm not sure if that happened in that case, if Judge Koh allowed Quinn Emanuel, which represents Samsung, to talk to the press. So the Wall Street Journal, Jessica E. Vescalaro, she had a story out. I guess they came out right away on the 25th, actually last night, regarding what was going on in that jury room. And she basically, it's clear from the description that this jury did their job. They worked out a system. And I guess they interviewed juror Manuel Ilgan, and he said that initially they were stuck on the first patent. 7 voted yes, 2 voted no for the first patent regarding the bounce back action on the iPhone. And it says here, with the votes tallied on a whiteboard, they decided to review the evidence, and they powered up a video of a computerized touchscreen tablet that had been developed by Mitsubishi that Samsung asserted proved that Apple didn't come up with the idea first and that its patent should be invalidated. And it says here they were huddled around a large oval table in a conference room. And on one side, there was a large whiteboard. On the other side, a refrigerator and a coffee machine. And it says that Mr. Elgin, who is 59, said that they watched the video very carefully, but decided to move on when the two weren't swayed, the two, outliers. And they did a very good thing. They said, we didn't want to get bogged down. And he happens to work at a company that makes circuit boards. And then they moved on to the And it says that later on, with the bounce-back patent, the jurors eventually decided unanimously that Samsung infringed it. And they did this all in 22 hours. It says that from the opening moments they devised a system to tackle daunting tasks before them. They remained focused, with jurors presenting others from going off topic. And they didn't discuss anything but the case. It says here, you know, they had to fill out 300 separate little fields on a 20-page verdict form. But look, a lot of the fields are repetitive. They had these phones in there, and so once, you know, there was like 6 or 7 patents at issue that Apple had. So once they decided these patents were valid, I think they just picked up the phones and looked to see quickly, you know, does it look like it's violating it? The one juror, Velvin Hogan, who's a video compression expert, kept them on point, according to this article, going question by question, while an AT&T product manager juror named Peter Catherwood took up the task of polling the group when they got a new question. So there's a, you know, a very diverse group of people here. It says one of the jurors worked in a cycling shop, and he organized the evidence, keeping tabs on more than 24 devices. So this is a very good Wall Street Journal article. I'll have a link to it. You know, so I think they really, you know, were very focused. Mr. Elegant said that the Apple lawyers were better at presenting their case. He said, I had an open mind, but most of the time was on the Apple side based on the evidence. They also, according to Mr. Elegant, said that the jurors easily rejected Samsung's argument that Apple infringed 2 patents related to data transmission. Samsung argued that it deserved $399 million in royalties. Elegant said that the jurors unanimously agreed with Apple's defense that since Intel Corp made the chips for Apple and Samsung, that Intel had given them the license. Now, Bloomberg seemed to have talked to a different juror. Bloomberg Businessweek News, in a story by Joel Rosenblatt, Karen Gulo, and Douglas McMillan on August 26. That's today. They interviewed Velvin Hogan, who was the foreman of the well, I don't know if they interviewed him, but apparently he gave an interview, and he was the foreman, and he said in an interview, according to Bloomberg, that the jurors went through a meticulous process of determining that Samsung infringed Apple's product. It said that when it came time to determine whether the infringement was willful or intentional, Mr. Hogan said that, quote, we knew we had to go in the evidence, end quote. Hogan said, referring to the emails. The emails included an internal 2001 Samsung message describing how Google asked it to change the designs of its products to look like Apple's. And also Hogan has said, certain actors at the highest level, this is a quote, at Samsung, gave orders to the sub-entities to actually copy. He said, and then, quote, so the whole thing hinges on whether you think Samsung was actually copying. The thing that did it for us was when we saw the memo from Google telling Samsung to back away from the Apple design, end quote. I guess Mr. Hogan's a 67-year-old San Jose resident. He said, quote, the entity that had to do that actually didn't back away. So that was pretty damning. You know, these are very damning, you know, statements. Hogan said that the group pressed through deliberations without any formal coffee breaks, worked through lunches, and deliberated for an hour longer than scheduled on 2 of the 3 days. So kudos to this jury. They really worked hard. He said Hogan, who, according to the article, says Hogan, who told the court he had served on 3 juries in civil cases, has 2 children in their 40s and spent 7 years working with lawyers to obtain his own patent covering video compression software, a hobby of his. And he worked in the computer hardware industry for 35 years at companies including Memorex Corp and Massachusetts-based Digital Equipment Corp. At some point he said, quote, when I got this case and I started looking at these patents, I considered, quote, if this was my patent, and I was accused. Could I defend it?" End quote, Hogan explained. On the night of August 22nd, after closing arguments, he said, quote, "A light bulb went off in my head," end quote. He said, "I thought I need to do this for all of them." Wow. So it says here, during the next full day of deliberations, Hogan said he explained his thinking to his fellow jurors. Quote, "We discussed each and every patent, each and every claim, each and every limit described in the patents," he said. He goes on to say, "We took this extremely seriously. We looked at it meticulously. But the way we looked at it, a lot of things grouped together," he said. "The group cut through unnecessary work by hand-drawing a matrix on a notepad to illustrate which patents Apple said were infringing by as many as 26 Samsung smartphones and tablet computers," he said. He said the process also helped to identify which sets of legal rules to apply for the 3 different types of claims at issue: utility patents, design patents, and trade dress. He's quoted as saying, "While on the outside people thought we got through this quickly, our method was we threw some things out that didn't need to be considered." This also points out that the group included a mechanical engineer, an aspiring software engineer, and a woman who worked for the National Semiconductor Corp. It goes on to say that R.T. Marther, who told the court she had worked at information technology startups as a benefits administrator, spoke briefly about serving on the jury, her first after the verdict. She said, quote, "It was a very exciting experience and unique and novel case," she told in an interview. She said, quote, "There was a lot to go through and we were able to sort it out." Now, CNET, I guess, had the interview with Manuel Ilgan, which really sort of clarified how detailed their deliberations were. And he said, "We found for Apple because of the evidence they presented. It was clear there was infringement." He said that the most compelling evidence was the following. He said, quote, "Well, there were several," and this is on CNET's website, and I'll link to that. He said the emails that went back and forth from Samsung execs about the Apple features that they should incorporate into their devices was pretty damning to me. And also on the last day, Apple showed the pictures of the phones that Samsung made before the iPhone came out and the ones they made after the iPhone came out. Some of the Samsung executives they presented on video from Korea, I thought they were dodging the questions. They didn't answer one of them. They didn't help their cause. He goes on to say another area where Samsung lost the jury was claiming that Apple violated 2 of its own patents relating to 3G wireless. They believed the exhaustion defenses. Other highlight here is the decision was very one-sided, he said, but he said it wasn't clear that the jurors were largely in agreement until after the first day of deliberations. And he's quoted as saying the following: "It didn't dawn on us that we agreed that Samsung had infringed on the first day. We were debating heavily, especially about the patents on bounce back and pinch to zoom. Apple said they owned the patents, but we were debating about the prior art, about similar technology that Samsung said existed before the iPhone debuted. Hogan was the jury foreman. He had experience. He owned patents himself, so he took us through his experience. After that, it was easier. After we debated the first patent, what was prior art, because we had a hard time believing there was no prior art. In fact, he says we skipped that one so we could go on faster. It was bogging us down." This guy, Lagan, responded to those who suggested that jury came in a verdict in haste. He said, "We weren't impatient. We wanted to do the right thing and not to skip any evidence." But he did say that the process moved quicker because of the following. He said, "Once you determine that Samsung violated the patents," Ilgan said, "it's easy to just go down those different Samsung products because it was all the same, like the trade dress. Once you determine Samsung violated the trade dress, the flat screen with the bezel, then you go down the products to see if it had a bezel. but we took our time. We didn't rush it. We had a debate before we made a decision. Sometimes it was getting heated. So, I mean, it sounds from these interviews that they really thought through it. He said, quote, "We weren't going for Apple. We were going by the judge's instructions on how we should go about it, and we stuck to that. We weren't thinking Apple or Samsung." He also said, "I was vocal about the technical issues, about the power controls, because I know that stuff. I work on that." He has a bachelor's degree in mechanical engineering. And he's also said, "I realize that's a big deal if Samsung can't solve those phones, but I'm sure Samsung can recover and do their own designs. There are other ways to design a phone. What was happening was that the appearance of Samsung's phone was their downfall. You copied the appearance. Nokia is still selling phones. BlackBerry is still selling phones. Those phones aren't infringing. There are alternatives out there." Wow, that was really powerful. I mean, these jury interviews, I think, are really powerful. And if you have any doubts as to how good the jury process is and how important it is in our country, please check out these stories by CNET, Bloomberg, and the Wall Street Journal. So what's next in the litigation? Well, things aren't over. Things are going to get hot and heavy. And that, I think the next thing that's going to happen is, well, it's clear there's going to be a September 20th hearing and to consider all motions. The judge set this down on Friday. And so what are the kind of motions that could be heard on September 20th, which ironically is the day that a lot of people think that the next iPhone is going to be sold. All the rumors have it that Apple's going to announce on September 12th the new iPhone, and that it's going to go on sale on the 21st, I think, which is a Friday. And that Thursday is going to be a big hearing date, and I think there's going to be all sorts of motions. Now, both parties can move for directed verdicts, and what that means is the party can say, look, what the jury did was wrong because the facts don't support, the facts aren't clear enough or way in favor of supporting either granting a claim or denying a claim. So Samsung could say, on all those things that Apple won, judge, the jury's wrong, the evidence is wrong, and you should set it aside and dismiss the claims. Alternatively, Apple could also cross-move for a directed verdict and say, look, on some of those claims that we didn't win, the jury was wrong. The jury should have found. Now, some people have pointed out Apple could move for a directed verdict on the patent that Apple lost regarding the iPad dress, the iPad design, because the jury basically said that the Galaxy Tab did not copy the design of the iPad. But that's really weird, and here's why. Because earlier in the lawsuit, Judge Koh granted a preliminary injunction banning Google from selling that tablet device based on her finding that Apple's patent was valid and that Samsung had violated it, and that there was a strong likelihood that Apple would prevail at trial on that patent. So it's a little weird for the judge to make that extraordinary finding and then the jury to say no, that it didn't violate it. So Apple has a shot at getting a violation or overturning the jury's decision on the one sort of area that it lost on, which was the iPad patent. Now, Samsung, I don't think Samsung has any chance of overturning any of these patents because, it's a very complicated factual case. There is great evidence in support of Apple's case. You heard the jury talk about it afterwards. I mean, I think the internal presentation, Samsung produced in discovery this internal PowerPoint where designers at Samsung went point by point through the differences between the iPhone and their devices and how the iPhone was better, and basically recommended that they implement what the iPhone had. And then, of course, there's the emails, which basically say where Google's telling Samsung to not copy Apple so closely. So I don't think really Samsung has a chance to get a directed verdict. Now, the other thing that could be done on the 20th is Apple can now move for treble damages, because under Section 284 of the Patent Act, it provides that damages may be enhanced up to 3 times the compensatory award after a finding of willful infringement. And here the jury was repeatedly asked, was there willful violation by Samsung? And they said yes. And this is really left to the discretion of the judge. Now, a case where this recently happened, according to a web search, is something that recently in New York, in the Eastern District of New York, in a case called Mezzo Minerals versus PowerScreen, EDNY. It was issued in December 8th, 2011, sort of applied that standard and held that a full enhancement of damages was not appropriate in light of certain mitigating factors. So what are the factors that the court could look at? The court can look at a lot of factors. Now the question is, can the court decide that the conduct was not willful? But there are mitigating factors. So, for example, if Samsung, before violating and coming out with these designs, got specific opinions from patent attorneys saying, I don't think this design that you're making is going to violate Apple's patents, that could be a mitigating factor. So that goes to whether, they acted in good faith. So the judge could, I guess, overrule the decision by the jurors that it was willful and find that it wasn't willful. If things come in like, but why didn't Samsung produce those counsel opinion letters during discovery or in the trial? I didn't see in the trial any lawyers testifying that they advised Samsung that these devices don't violate any patents. So I don't think they're going to have that defense. Because if they did that, then Apple would have been able to depose the attorneys who came out with the opinions and say, hey, did they give you all the information? But other factors here, according to the analysis that the court used, was whether the infringer deliberately copied the ideas or designs of another. And it appears here that there are findings and there's evidence that Samsung did that. They specifically, it's not like Samsung, happened to develop this and never looked at the iPhone. There's these PowerPoints which show them deliberately going through the blow-by-blow of the iPhone. Another factor is whether the infringer, when he knew of the other's patent infringement, patent protection, investigated the scope of the patent and formed a good faith belief that it was invalid or that it was not infringed. And I don't recall in the trial any testimony coming from attorneys, like I said. But here's an interesting factor: the infringer's behavior as a party to the litigation. So if the infringer was like obnoxious in the litigation and difficult, then that's something that the court can take into account as an aggravating factor. Now here there is evidence that Samsung, was very difficult and obnoxious in the litigation. It filed crazy amounts of motions. And then let's not forget, the day the trial started, its attorney, John Quinn, after being unhappy that the judge wouldn't allow certain evidence in, Samsung, with the attorney's approval, issued a press release saying that there wasn't any justice in the court or something like that because the evidence didn't come in. And then, of course, there were like little things like Susan Estrich, one of the attorneys for Samsung, appeared and argued a motion, and she was not admitted in the court in violation of the court's rules. And then, of course, it was found that prior to the lawsuit, Samsung had a practice its policy regarding emails was to have them automatically deleted. And after Apple advised Samsung in the summer of 2010 that it was violating its patents, Samsung only put a litigation hold and tried to preserve emails of only a small group of Samsung employees, like 14 or so. And initially, Apple got a great ruling from the magistrate saying that there would be an instruction to the jury regarding that. But in the end, the judge sort of said, no, both sides had done that. So, but here, Samsung's the infringer, so that could be an aggravating factor. But another factor is the defendant's size and financial condition. And here, Samsung is enormous and has huge resources. So, because it was willful, the judge could find that double or treble damages are needed to send a message to Samsung that you can't do this, because $1 billion, frankly, isn't going to make a dent in this case. And then another factor is the duration of the defendant's misconduct. Well, obviously, it went on for a lengthy period of time here, and the remedial action by the defendant. Remedial action is the defendant fixing the problem, and I would say no, Samsung is not fixing the problem, because Samsung refuses to acknowledge that it infringed and really hasn't done anything to cure the problem. And then the defendant's motion for harm, and whether the defendant attempted to conceal the misconduct. Well, there is some evidence that the defendant attempted to conceal the misconduct, as it didn't shut off its automatic 2-week deleting of emails policy. So in this case that happened in New York earlier in the year, the court generally found mitigating factors. They didn't find like abusive behavior during the litigation, but it did enhance the award. Yeah, in that case, it found that the duration of the misconduct weighed in favor of enhancing the damages award. It said that the defendant continued to sell the infringing screeners during the entire 4.5-year pretrial period, during the trial, and post-verdict. And in that case, the infringement acted for 11 years. So the fact that it continued during the trial and during the litigation was a basis for the enhancement in that case. And here, Samsung obviously is continuing the violations. They considered a post-trial press release made by one of the defendants stating that the damage award will, quote, not have a material impact on its business. So the press release was used by the court as support for enhancing the damage award. I think Apple has a decent shot of getting a multiple of the $1 billion damages that the jury awarded, maybe twice, maybe 1 time, maybe 3 times. But I think, my guess is that at least $1 billion is going to be added to this damage award by Judge Koh. Now, Samsung's post-verdict statement could hurt it in its efforts not to get further penalized by Judge Koh. Because if you look at those factors I was discussing in terms of the treble penalty analysis that the judge could impose, sort of addressing the infringement and fixing it and recognizing it and trying to not infringe is one of the factors on whether or not a message needs to be sent to the infringer, in this case Samsung, through a further penalty. But this is what Samsung said, and I have the quote on the video. It said, Today's verdict should not be viewed as a win for Apple, but as a loss for the American consumer. It will lead to fewer choices, less innovation, and potentially higher prices. It is unfortunate that patent law can be manipulated to give one company a monopoly over rectangles with rounded corners, or technology that is being improved every day by Samsung and other companies. Consumers have the right to choices, and they know what they are buying when they purchase Samsung products. This is not the final word in this case, or in battles being waged in courts and tribunals around the world, some of which have already rejected many of Apple's claims. Samsung will continue to innovate and offer choices for the consumer. So here's the thing, Samsung, by being so defiant, could leave Judge Koh with no choice but to impose hefty additional damages against Samsung, because Apple could argue, listen, all you've done is taken away the gain that Samsung got through the infringements, the Apple's damages, and you need to punish Samsung for the willful infringement, because Samsung did not accept responsibility. Samsung did nothing to stop this infringement, and in fact, this could also help Apple in getting injunctions, because what I had on terms of what's going to happen on September 20th, Apple wants injunctions. Apple wants basically the court to order Samsung to stop infringing those patents, and as specific performance, the court could say stop selling those devices. But the injunction that Apple can get from the court will basically put Samsung on notice that if it continues to violate the patents, Samsung could be held in contempt of the court's injunction. So, and one of the standards for an injunction is there a possibility of irreparable harm, and is there a possibility that the infringer will continue to infringe the patent? Well, Samsung, through its statement, is basically saying it doesn't recognize any violation. So if it doesn't recognize any violation, it's in danger of, again, violating the patents. So Apple has a strong basis to go back and get an injunction. So I think, Samsung's in a catch-22 situation, because if it wants leniency from the court, it should say, oh, I did something wrong, I'll fix it, I'll make sure my phones don't again infringe Apple's patents. But that's not what Samsung's saying here. Samsung is defiantly saying that it did nothing wrong and it's going to continue to fight this. And that could be a basis for the court to impose substantial penalties. Now, if Samsung is not able to convince Judge Koh at the September 20th hearing to reverse the jury's decision, and, this judgment, a judgment is entered for $1 billion plus an injunction, or the court increases the judgment beyond $1 billion, Samsung can appeal. And if Samsung appeals, I think it has to post a bond for the amount of the judgment, because otherwise, what if Samsung fritters away the money while the appeal's pending? And if it wants a stay of the judgment, in other words, the injunction, so that it's not enforced while it's appealing. And I think Samsung has clearly the money to post a bond for the amount of whatever the ultimate judgment is. The question, though, is will it win its appeal? And I don't know. I think it's kind of hard. I think, Apple's really winnowed down its case. And I think Court of Appeals are kind of low to overturn jury verdicts. One basis for an appeal is to say that the judge gave wrong instructions. But, Judge Koh is very conservative. For example, she could have easily followed the magistrate judge's decision to give an instruction that Samsung had engaged in spoliation before the case started and allowed emails to be destroyed. But in the end, she balanced out the instruction so that they got the same instruction for Apple, that Apple should have done a better job preserving emails. Similarly, Judge Koh could have sanctioned or done something to Quinn Emanuel and John Quinn for when they sort of made that statement the first day of the trial, broadcasting the exhibits that the judge didn't allow in. And she was very conservative and did not sanction anybody. and it didn't even give Apple the instruction Apple wanted. And frankly, if anything, it seemed like Judge Koh was bending backwards to not be harsh to Samsung. And so there's not a lot of grounds for appeal. I mean, one thing that Samsung might try to appeal is the judge, I think, gave each side only 25 hours to put on their cases totally and their defenses. And Samsung said this was unfair, but I don't think that they can appeal that, because the judge has a right to control its docket and how quickly cases go, and Samsung doesn't have a right to unlimited time of the court. This is not a criminal case. This isn't a death penalty case. This is a civil litigation, and the judge has a right to control the docket, and a multi-week trial is perfectly fine, and the judge has a right to put limits on how much time both sides get. And, you know, Samsung as well as Apple put in crazy amounts of exhibits and motions and docket entries. So I don't know. I don't really think Samsung has a really decent chance to win an appeal here. So what does that mean? So what is the value of this victory for Apple? It's a lot of money, $1 billion, and the court can impose, you know, maybe another $3 billion on top of it, or $3 billion totally. But it's not the money, because if you think about it, look, Apple, I think, made something, I don't know, like $9 million in profit, or maybe more in any particular quarter. So $1 billion, even though it's a hefty, crazy amount of money, is not crazy amount of money for Apple, which makes tens of billions of dollars of profit in 1 year alone. So it's a fraction of, you know, to the total profit that Apple can get. You know, and if you think about it, I think there's like a little under 1 billion shares outstanding of Apple common stock. So $1 billion is like $1 dollar for every shareholder. And the stock is, I think, trading at like $670 a share or so. So it's like $1 per share when the stock is worth $670 per share. So, but it's not the money. The big value here is that Apple's patents were held to be valid. This is for the touch zoom. This is for the bounce. This is for the face of the iPhone, the back of the iPhone, and Samsung was found to have been an infringer. And essentially, in the public eye, Samsung has been found to be copying Apple and infringing. And so the big value is what's known as collateral estoppel, because these patents are valid, and Samsung, if it's ever sued by Apple in the United States on the patents, can't litigate again. So the doctrine of collateral estoppel is a legal doctrine which says if you've personally lost an issue against another party, you can't really litigate the issue again. So Apple can use this collateral estoppel doctrine against Samsung again. In other words, the question is, can Apple use this against other Android device manufacturers? You know, for example, if it goes after Motorola or HTC, will the fact that these patents were found valid against Samsung allow Apple to say, look, we don't have to fight over this again here because it's already been determined? And I don't think so. I think HTC would get a shot to re-argue that the patents aren't valid. But here's the thing. A judge might grant a preliminary injunction because a court has already found that they're valid patents. So if Apple sued, let's say, other manufacturers of Android devices on these patents, the issue that there are these valid patents might not be able to be litigated against, or a judge might say, look, I'm granting summary judgment and finding that, you know, given that another jury already found that these are valid. So that's a big value. But the other big value is that it sends a message to the Android world that you're going to have to pay. Like, you might not pay the royalties that Apple wants, but Android's not free. And I think that's the thing that upset Apple the most, was that Google was Apple's partner, and then Google gave away this free operating system to Apple's competitors, and that it's unfair because the competitors don't have to pay anything for the operating system. And by making the competitors pay for it, maybe the competitors will now not necessarily embrace Android or try to change it to make it very different than the Apple iOS. But the other big winner here is Microsoft, because Microsoft's, one of the executives tweeted something like, Windows 8's looking really good, because, Microsoft charges for its operating system, but now OEMs like Samsung might think, hey, maybe we should develop Windows, because at least we know that if we pay Microsoft for Windows, it's got patent protection. Because one of the things that came out in this trial was that Apple entered into cross licenses with Microsoft. So I think the big thing here is that it could cause significant change in how the Android manufacturers make the, how Google makes the Android operating system and how the manufacturers make the devices, that they're going to go out of their way to make them maybe look different than the iPhone. So it is something that is going to help Apple prevent copying. And Apple, Tim Cook, in a statement internally said this case was not about money, it was about values. And I think Apple is saying, like, look, we're not into copying. We don't want people copying us. So this could really help Apple stop that. So anyways, I don't want to make this podcast too lengthy, but I will talk about it maybe again next week. Okay, so that's it for episode 126 of the Apple Podcast. This is Lex at Macs Future. Thanks for listening, and you can help out this chit-chat-free podcast by going into iTunes and giving it a positive review. Thanks for listening.
This has been a Macs Future production.